In this video, we're particularly looking at what happens in the situation that a contract is not fulfilled by both parties. What can one party do? What can one side of the contract do in a legal sense if this happens? For example, someone might have a contract with a builder to do some work. If the builder doesn't fulfil their part of the contract, the question is what sort of things might the person who is using the builder be able to do? If there is a breach of contract, and it's a situation where that breach doesn't just mean that the contract is ended, then the person who's been negatively affected, the innocent party, can sue for specific performance. That is, sue to make the other party do some specific work for them. They might sue to get an injunction, which is to stop the work, and they might sue for some damages. If this breach of the contract has caused them some damages, they might look to recover that through the court. And we'll look at each of these in more detail. Specific performance is a remedy that involves making the defaulting party carry out the contract as originally agreed. So let's think of an example. If you were having a ship built, not just a small tinny that you might go fishing in, but a serious, maybe a 30-foot fiberglass boat that was being especially manufactured for you for commercial use. It might be very hard if the contractor that you've set up, you've signed a contract with the shipbuilder. If the shipbuilder says they're not going to finish off the project, it might be very hard for you to get anyone else to do that work. So one of the things you might do is go to the court and say, well, in this case, what we really want to see happen is this shipbuilder to finish our ship as per our contract. It's only granted if damages, money, are not an adequate remedy. So in this case, you could sue the shipbuilder for money, but that would still not finish off the job of building your ship. And also then it requires the court to be able to supervise that order. So they have to be able to see that what is being required to be done is actually being done. And they could do that in this case because they could monitor how the ship is being built and could get feedback from both parties of the contract that it's been done satisfactorily. The second thing you might get is an injunction. Injunctions are used in different roles in the law, but basically what it means is putting a stop to something. An order that restrains or stops a person from doing something is wrong. For example, think about that ship situation. There may have been specific requirements for the materials to be used to be of a certain standard. If the person who's having that ship built for them has concerns about that, they might get an injunction to stop the work and then to go and have a look and check that the materials are up to standard. So in this case, an injunction is used to restrain a person from doing a wrongful act or to look into what has to be done. The third thing is suing for damages. To sue for damages, first of all, there has to be a loss. There has to be a financial negative impact on a person. And that negative financial impact is referred to as damages. The courts awards a sum of money as damages. There may be an actual loss. They may be able to prove exactly what the loss has been. For example, a builder that carried out a project didn't use the right materials and the incorrect materials had to be replaced and proper ones put in, well, you'd know exactly what the cost of that project was. At other times, it might be an estimated loss. Thinking again of that building situation, maybe something hadn't been carried out properly, that reduced the value of the home, and they would have to estimate what that loss might be. The basic principle, and this is fairly important, is that the injured person is entitled to recover an amount that will put him or her in the same position as if the contract had been performed properly. A number of other issues that are important with respect to damages from breach of contract. First of all, the damages must not be too remote. As an example of this, if you were getting work done and you had a contract to get work done in the house, something wasn't done properly, and you claimed that put you in a bad mood and it meant that you weren't doing well at work and you didn't get a promotion, those sort of thinking would be fairly remote from the actual problem, which is the contract of the house. The person claiming the damages has a duty to take all reasonable steps to minimise the loss from the breach of contract. So once you think there is a breach of contract, it's your job to make sure you're doing everything you can to keep that breach as small as possible. You can't just let the work go on without getting involved at that stage and say, oh, well, we'll just all sort it out at the end. It's your job to take actions that keeps the loss as small as possible. Damages are not usually given for disappointment or distress. There was a case that we looked at from the textbook where people who'd been on a cruise and the cruise had hit a rock partway through were given some disappointment or distress, but that is unusual. Usually it just deals with the facts around the loss, the damages that have occurred relating to the contract. And there are time limits that people have to sue. So for Queensland, for a simple contract, that is 6 years. The other thing we have to be aware of, although I would suggest this is the less important part of this presentation, are the implied statutory conditions. So this is a fairly fancy term, but what it means is these are the terms that exist, even if they're not stated explicitly, especially when you deal with a retailer, when you're going into a shop and buying some goods. So there are various laws that cover consumers. In Australia, the Competition and Consumer Act 2010 is a Commonwealth Act that covers all consumers. In Queensland, it's the Fair Trading Act 1989 that covers consumers. There is the Australian Consumer Law within the Competition and Consumer Act 2010 and provides various consumer guarantees, including goods must be of an acceptable quality, they must be fit for any disclosed purposes. So that means if someone has said that they're fit for something, for example, let's go back to the boat example, I buy an outboard motor to go with my boat, well, that has to be fit for the purpose I describe. For example, if that boat is going to be used every day, driving people to and from an island, then the goods must be suited to that if I've discussed that at the point of purchase. They must match their description. If I'm buying a red toaster, then, and that's what's described to me, then that's what I need to get. Importantly, it's not just about goods. A supplier of services, so services might be anything from going to visit the doctor, a teacher delivering education, a hairdresser. A supplier of services to a consumer guarantees that the service will be delivered with skill and care. And the guarantees in Australian consumer law can't be excluded by the terms of a contractor. If you go to a doctor, for example, they can't ask you to sign a contract that says that they don't have to act with skill and care, Section 60 of ACL. These statutory obligations, these obligations that come about through statute, so that's the laws, are split into two areas. One is that not a major failure. So if there's just a failure that's not considered major, the consumer can require the supplier to remedy the failure within a reasonable time. And if that's not done, the consumer can reject the goods and get their money back. If it is a major failure, where the goods are unsafe, unfit for purpose, or different from what was demonstrated, consumer can either straight away reject the goods and get a refund, or recover compensation for any reduction in value. For example, thinking back to that the example of the boat and buying a motor that would be suited to the boat that's used on a daily basis. Well, if there's something there that hadn't been fit for the purpose, but the boat motor was still useful for other things, it might be, say, well, a negotiation that says we're not prepared to pay what we initially offered, but we'll reduce the price and do a deal there.